Now I am going to deal with the provisions relating to employment of funds by the banks or employment of bank funds. As an introduction could be given like this. Bank fund is a combination of their own fund as well as the borrowed fund. When I say their own fund, that consists of paid up capital, then reserve fund, the other reserves, the undistributed profits, etc. They in course of time, undistributed profits and all, in course of time they become their own fund. And there are also borrowed fund like deposits received from the public, borrowings from the Reserve Bank, from other commercial bank, etc. So you as a whole, while carrying on the business of banking, all the banks in one way or the other they mobilize savings, they mobilize deposits from the public for the purpose of lending and investment. Why do you mobilize? No, you are a chief source of capital formation, Mr. Bank, and you are able to mobilize this. You are able to save. You are able to promote the saving of money. You are able to inculcate that habit in the people. Thus, you are able to mobilize the deposits from the people. Whoever finds surplus after necessary expenditure, after their expenses, they save some surplus. And you are able to mobilize those surplus into the form of deposits by opening the account. Therefore, you render that main objective, that main contribution of capital formation. So, you are able to help them because they have saved the money by your system. And you are helping the other living in the society, other people in the society, because those who do not have money, you are able to make money available to them by your lending operations. And as we know the definition section 5, what definition section 5 of the Banking Regulation Act says? Banking means acceptance of, for the purpose of lending, acceptance for the purpose of lending or investment of deposits of money, repayable on demand or withdrawable after repayable on demand or after the expiry of certain time, and withdrawable by checks, orders, etc. This is what we mean by acceptance of deposits of money from the public, which is repayable either on demand or otherwise, or withdrawable by draft order or otherwise. What for? This acceptance of deposits. This acceptance of deposits must be for the purpose of carrying out the other basic function of your banking. What is that? The chief main function, regular function of banking should be mainly concerned with the acceptance of deposits and the lending of funds, lending or investment of funds. But the question now, whose money you are whose money you have accepted? It's a public money you have accepted. For what purpose you have accepted? For carrying out your other basic function, that is lending or investment. And while making that lending by way of loan, as we have seen what are the different forms of what are the different types of creation of money or manufacture of money. Banker forms the money, banker creates the money. The creation of money happens when the bank performs its operations. A commercial bank we have seen, Reserve Bank we have seen. Rather commercial bank. What are the functions of commercial bank? Acceptance of money, acceptance of the deposits into various accounts, lending, advances by way of loan. Yeah, you will see. By way of loan, overdraft, cash credit, discounting of bills. Then we have seen investment of money. Then we have seen creation of money or manufacture of money. How creation of money? By way of loan, advances, overdraft, cash credit, purchase of securities, then discounting of bills, purchase or sale of securities, discounting of bills. You manufacture money, you creation money. We have discussed that while dealing with the functions of commercial bank. What for? The basic objective that you carry on these functions, you have carried on The first one is that acceptance of deposit. And you have promised to pay them the interest, correct, returns. And it depends whether it is savings account, whether it is a fixed account, whether it is a recurring account, etc. Of course, to the current account you don't pay interest. In fact, if it is burdensome, you may affect charges on the current account holders. But as far as the other three account is concerned, you will pay one or other form of interest. But to pay them interest, to get your own expenditures, get your own infrastructural or administrative expenses realized, you need to earn, Mr. Banker. How do you earn? By making a necessary investment. Correct? You will earn by making a necessary investment. You will earn by lending, loans. I mean various, as I said, overdraft, loan, medium term, short term, and long term, whatever. And how do you need to employ the funds. You need to employ the funds, otherwise it will be a burden, otherwise it will be a liability. How will you be in a position to pay them, customers, the agreed returns, depending upon their nature of the accounts? How will you pay? You will be able to pay only when you carry on your other main function of banking, that is lending or investment. And while making lending or investment, while advancing loan or while giving a loan or advances, you have to be extra careful. While making investment of the bank fund, you have to be very, very careful. Reason, it is a public money that you are investing. There is a word, it says, your money, my brain, our bank. Your money, public money is applied by using my brain. I am familiar with the market conditions. And I am having the skills of making and giving away the advances or making investment. I have the experience, skills, necessary knowledge as to where it can be employed, where profitably it can be employed, etc., etc. So, banker, you need to employ the funds if you are to run profitably. You need to employ the funds by way of loan or investment, correct? And while making the employment, while doing that employment of bank funds, you need to be very, very careful. Since out of the employment of the funds, if you are only bothered about the returns, then sometimes you may be failing. But therefore you are expected to follow you are expected to take extra precautions. You are expected to follow some sound principles and other principles of banking, while making while doing this, making investment of bank funds, either by granting of loans of different nature or different forms, or either by making investment of the bank funds. But while making investment, while employing the bank funds either by way of loans or by way of investments, you will have to be considering several precautions. And unless you observe those precautions, you will not be in a position to run the bank you will not be in a position to earn a quantitative returns. If quantitative, sizable, recognizable returns are required to be done, required to be obtained, then you need to make investment. And your investment in funds of various assets, like both income earning and non-income earning assets, the bank is guided by some statutory requirements, some sound principles of banking, and even you are guided by some statutory requirement while employing the bank funds. You are required by statutory requirements. You are required to adhere to sound principles of banking and other principles of banking. You are even guided by, you are even bound by Reserve Bank of India directives and many other considerations. And the most important considerations that we are to observe for the bank while employing the bank funds, so as to find some recognizable returns, so as to find the bank earning doing good. I think banks are to be guided by sound principles of banking. What are those sound principles of banking? Let us discuss with reference to those sound principles. Sound principles of banking. What are those? We need to study them. One sound principle, while employing the bank funds, whether by way of granting loans or advances, or whether by way of granting loans as against the securities, either goods movable or immovable, like that of mortgage. What are the various sound principles that you need to adhere to strictly? One, the sound principles of banking. Safety, yes. See, don't think only in terms of profit, commercial. Sometimes your thinking may go fatal if it is not repaid. Therefore, you should always ensure that the money you lend by way of loan, money you invest, they must be safe enough. Safe enough in the sense that it must be ensured of it, secured of its repayment. Safety or security. Then liquidity. Then profitability. You are to be guided by these three principles. And there is one more, while making such a employment of bank funds, you please also make sure that responsibility. It is also, see, lending or investment is not only your prerogative, it's not only your right, it is also a responsibility. Responsibility means social responsibility, social good. That's what I mean to say. Okay. These are the four sound banking principles. Namely, safety, liquidity, profitability, and responsibility. Okay. The fund which you employ, the bank fund, from where it is collected from, you got to know that the chief source of bank fund is the deposits made by the public. Okay. Therefore, you have to be very careful. See, public, the customers will keep coming, and they deposit to their accounts with all the hope that banker will follow some sound principles of banking as known to them. When the banker carries on banking business on sound lines, then there is less chances of any crashing, or less chance of any fatality, or less chance of any banker going to liquidation. So therefore, with that good faith or bona fide belief, they have they carry on banking operations with your bank. Therefore, are you not expected to comply with that? Is it not a legitimate expectation of the people that the bank will bank will be guided by sound principles and other principles of banking while carrying on banking operations? It's a legitimate expectation of the customers. It's a legitimate expectation of the public. That is why they are into your bank to carry on banking business. When such is the case, you are bound to conform to their legitimate expectations. You are not supposed to. So therefore, while of course, not only that, their expectations, but also you are guided by, to ensure that you will employ the funds properly, you are guided by statutory, you are guided by laws relating to the same, like a Banking Regulation Act, Negotiable Instruments Act. Statutory requirements you have to comply with, Mr. Banker. You have to comply with the even sound principles and other principles of banking and the RBI directives, RBI circulars, etc. So RBI restrictions will be there for you to in connection with the employment of bank funds. As I said, first sound principles of banking, ensure always on the safety of banker is a dealer in mainly in other people's money. As we know, banker is a dealer in debts, his own and others. Since he is a dealer mainly in other people's money, that is depositors' money, hence he is required to take look into the safety of funds belonging to the depositors. By safety or security, we mean the amount lent must be recoverable. It should be recoverable as such in full along with the interest. Okay, the repayment of the loan depends upon the borrower's capacity to pay and willingness to pay. Therefore, you must adhere to these principles of safety. You must adhere to the liquidity. You must adhere to the profitability is also required, and also responsibility. Okay. And all these could be gathered that when you are employing the bank funds by way of granting loans or advances, you will be guided by 3 C's. You will be guided by another 3 C's. You will be guided by 3 R's. What all those 3 C's? 3 C's, 3 R's, and 3 furthermore C's. It is like yes, while granting the loan, you are guided by 3 C's, namely the character, the capital, the capacity. Understand? The character, the capital, the capacity. 3 C's. Character, capital, capacity. Then there are some more 3 C's. What is that? Namely, collateral conditions, okay, conditions or circumstances and contribution. Okay, then there are 3 R's. What is that? Reliability, then that 3 R's we are referring to, namely reliability, responsibility and resources. See, while employing of bank funds by way of loans, then banker should be extremely careful while examining 3 C's. I mean, he should ensure that those 3 C's, one set of 3 C's, another set of 3 C's should be present, and also even the 3 R's. What is that 3 R's? Let us discuss the first 3 C's. 1, character of the borrower. He must be good, and he is not you must examine whether the borrower is reliable, honest, etc. That character of the borrower is important. Please examine. And examination is not by looking at him. Examination by inquiring about his dealings. Correct? And then capital. Whether when I mean to say capital, the third important factor, this is the important factor to be considered in assessing the credit worthiness, is the capital invested by the entrepreneur in the business. If the capital invested by the entrepreneur, that is your borrower, in his business is sufficient, then it infuses confidence in the creditors. Who is the creditor? Banker, for example. It enables him to meet the losses. So therefore, this is very important. When the banker lends to a businessman, when the banker lends to a customer, whether customer would be requiring that much of capital investment in a particular venture, when that much of capital is required to be invested in that particular venture, whether he would be in a better position to earn the returns, whether he would meet the requirements in the requirements of the business. So that is to be necessarily examined. And then capacity. Capacity means the capacity to make the repayment. You borrow rupees 2 crores to invest in a particular business venture, and whether you would be able to earn. I said your character is to be examined, your capital is to be examined, and your capacity to make, capacity in the sense, you with this loan, whether you will be able to, succeed in the venture for which the loan is needed, whether you will be able to make the repayment of the said amount. All these to be examined, Mr. Banker, you need to examine, and those 3 C's of your customer, 3 C's of your borrower, examine. There is one more set of 3 C's to be examined, that whether you will solely rely on the personal security of the borrower. It is better rely on the personal security of the borrower, that is always a must. In addition to the personal security of the borrower, you may also go for collateral security, that is additional security of some tangible objects. You understand? Either it is movable or immovable, it is up to you. Collateral security is additional security securing the loan by executing the tangible things. A charge is created in respect of, an interest is charged, interest in favor of the creditor, that is the banker, is created in respect of the borrower's movable or immovable property. That is why it is called tangible security, an additional security. These are all over and above the personal security. Created a tangible security to ensure the repayment. And the conditions and the circumstances. What is that? Conditions and circumstances, that is also required. When I say conditions and circumstances, refers to general trends in the trade or industry. General trends in the trade or industry in which the borrowers has interest. Okay? The borrower requires money to invest into a business. What is the general trend of the said business? Mr. Banker, you should be aware. What is the general trend of the said business as it appears now? Whether any investment of money by the customer borrowing from the bank, whether investing of that money into the bank I mean, whether the investment of that money which he had borrowed from the bank into that venture, into that trade or into that business, whether it can have currency today. Oh, that you should examine, Mr. Banker. You should clearly examine whether the customer who requires, whether the borrower who requires the borrowings, whether the borrower who requires the loan for that particular business or trade, whether that business or trade is good enough, whether it can have currency, whether it can earn like that. If that is a business which doesn't have any demand or which doesn't have any currency, then don't grant the loan at all. You understand? So you need to observe that also, that conditions or the very purpose for which the borrower requires the loan. What is the purpose, trade or business? What are the conditions or the circumstances? The business, what is the status of the business as it appears today? Whether business can be good, whether I could be granting, whether business can do good or sustain, or that business doesn't have any demand at all. If no demand, don't grant. Yes demand, examine the conditions or circumstances of that particular business in the present day market. And then contribution. That is also very essential. Yes, sir. Banker, you by employing your funds, by granting the loan to Mr. Borrower, whether borrower will be in a position to contribute, you have given the loan to the borrower, correct, for a particular purpose. Whether by administration of the money for the purpose for which it is granted, whether the borrower or the debtor, whether he is in a position to influence, whether he is in a position to contribute. This is also contribution refers to contribution with the borrower entrepreneur is likely to make to the people as well as the whole country, and banker is necessarily the chief source of such contribution, because banker has employed the fund by way of granting the loan, correct? Banker has employed the fund by way of making investment there. When you make the investment, the investee, the person upon whom you have made the company where you have made the investment, it would get money as such, and they apply the money. When they administer or employ, when you are made available with the money, you can make the investment. A banker has invested money in you, and you are doing some activity, and that activity is doing good. In order to do further good, maybe expansion of the business, you need money. You are provided with the money either by a loan or investment, and as a result of this investment or loan, you got the money and you are able to do better service. Whether that service is able to do good for the society, whether it is able to do good for the country. If you are, this is what I mean by social responsibility or social good. One of the sound principles of banking. Don't ignore any of these. Safety, liquidity, and profitability. You should earn a profit, otherwise you can't exist. And when you earn more and more profit, you can do better and better service, as we find the banking structure today. They are able to give. Technology-driven banking today is it is primarily on account of the earnings of the banker. Today it has bettered. Banker today is not only carrying on the main business, but is a subsidiary, ancillary, secondary or public utility functions have enormously got increased. As a result of that, bankers' earnings have got increased. And since its employment of the bank funds, since employment of the funds by the bank is subjected to stringent provisions, like sound principles of banking, like other principles of banking, I think banker is able to ensure that whatever sent, whatever lent, whatever invested is able to earn rich returns or dividends. Hence, we are able to find banking growth in this form as such. So that is what 3 C's: character of the borrower, capital of the borrower, and capacity of the borrower to make the repayment to examine. And then the other 3 C's, like whether while lending, whether you are only relying on the personal security. No. Additional security in the tangible securities, either movable or immovable, that is good collateral security. Then conditions of the trade or business for which you are granting the loan or making the investment, also examine whether that particular trade or business having some currency in the present day market or having demands when you invest or when the loan is granted for that business or trade. Then your investment by way of granting the loan or investment by way of investment, it will earn good returns. I mean, it is securable returns, I mean to say. Then you have granted the loan to that, or you have invested there. Whether that borrower or whether the investee, by with the help of that money that is made available, accommodated to them, whether they are able to contribute to the society, to the nation, that also to be. I think that this is also a contribution of the banker as such. Then you have to go by 3 R's. 3 R's of the borrower. What is the 3 R's of the borrower? Reliability, resources and responsibility. Reliability of the borrower. Resources for the borrower to make the repayment. You please ensure. That is what I mean by security. Not only granting the loan, but also you must ensure that loan granted will be recovered. That means he will have the resources to make the repayment. He will have the resources to make the repayment as such. And then responsibility. What is that responsibility? Banker, it is your responsibility to ensure that you are granting the loans. As we said, diversification of risk. Banker should not grant the loan only to one sector. Banker should grant loan to each or investment. Banker's loan or investment should be respecting to each and every sector, so that there will be some balanced growth we can find as such. Okay, right. There are also other factors which the banker need to be guided by. Purpose of the loan, as I said. What are the various, apart from these 3 C's, 3 R's, sound principles of banking, you need also to examine, Mr. Banker, that the purpose. These are the other principles. I will just state one by one. Purpose of the loan, the principles of diversification of risk. Okay, diversification of risk means you ensure that your lending or your investment will spread over to all the sectors wherein you can diversify the risk. Profit of one sector may set off the loss of the other sector. That is possible. Okay, and these other factors will also be principles which the banker will be guided by while always employing his funds as such. Okay, and while employing funds by way of investments, he should always go for investment in government securities, treasury bills, semi-government or trustee securities in public sector undertakings and industrial securities. While making investments either in the government securities or in the government treasury bills, government securities, semi-government or trustee securities, securities in securities of public sector undertaking, semi-government securities or trustee securities, securities of public sector undertakings, and the last one, industrial securities. In these securities, as I said, treasury bills. These are raised by the Reserve Bank of India, treasury bills. And these are raised by the Reserve Bank of India to accommodate the government of the state or the government of the center to find money for carrying out their welfare programs. But for carrying out the welfare programs, the government may not be finding instant money, but government is 100% hoping to find the money by way of collection of taxes, which may not be coming today, it may be coming tomorrow or day after, but you need money today. Therefore, treasury, by being their own bank, Reserve Bank of India, which will raise the treasury bill and sell it to commercial bank. Okay, it will sell it to the commercial bank. Remember, and thus it will make money, make available money to the government as such. Correct? Selling the treasury bill with the commercial from the commercial bank, it will be repurchased by the Reserve Bank. Okay, treasury bills, government securities, okay, LIC, as I said, all these. Then semi-government or trustee securities, government securities, bonds, I mean, okay. Then what? Semi-government or trustee securities, industrial securities. These are all securities in the public undertakings. These are all securities on which the banks can invest. The government securities consist of stocks, bonds, promissory notes issued by the government. They are fast and very secured securities as such, where price stability will be there, the regular yield will be there, and you can safely invest, Mr. Banker. Semi-government securities or trustee securities like gilt-edged securities, government or semi-government. The important to note that both government and semi-government securities are gilt-edged securities. The very name gilt-edged indicates that these securities are very safe securities. Okay. Then securities of public utility undertakings. Definitely there are various public corporations, public utility undertakings. In their shares, in their capital, you can invest. Okay, that is a good investment as far as security of returns are concerned. And industrial securities, that is private stock companies, stocks, shares, debentures, bonds of industrial, commercial or trading entities, you can make investment. But while making these investments, you are guided by safety, liquidity or marketability, profitability or yield, price stability and regularity of income. You are guided by Mr. Banker while making investment into any treasury bill or any government securities or any semi-government securities or securities of public sector undertakings or that of industrial securities. Mr. Banker, you are guided by the following principle, namely safety, liquidity or marketability, and profitability and yield. And next, price stability and regularity of the income. So you are very much bound by these principles and while employing the bank funds. Let us apply all these to each of the specific kinds of lending on the basis of bank advances. Okay. Bank advances. I am now going to brief that. Bank advances by way of loan, overdraft, correct? Cash credit, discounting of bills. We have already seen what all these bank advances. So while lending loan, be it short term, medium term, long term loans, overdraft, current account, cash credit account, discounting of bills when it is not yet due, but banker honors that, making sure that the drawee will, the banker will get the payment. He will honor on behalf of, he will make the payment, advance payment to Mr. Payee, but minus discounting charges, correct? But suppose if the said bill is not honored when it is due, suppose when the bill is not honored when it is due, then banker will come back to the payee to get the payment. But as making an accommodation in advance, he has already made the payment. This is what a loan as such. When the banker allows a bill of exchange, say for example, bill of exchange or a check, whatever it may be. In the case of check, post dated. In the case of bill of exchange, the drawee accepted the bill to become payable next month 25th, but you need money today itself. A banker will pay on the faith, on the confidence of that it is secured one, on the confidence that it will be honored on the 25th next month. He will make the payment today itself, because you are in urgent need of money, and I will pay you. I will not pay full amount which the bill of exchange represents. I will pay only 90% of the amount. Why? 10% is the discounting charges. Okay, this is done. You are made available the money. But on the 25th next, if it is not honored, if it is not accepted, if it is not paid, then the banker will come back to you to get the payment. What payment? 100% payment. Understand? Not the 90% payment he gave to you. You have to pay 100% of the amount which the bill of exchange represents. Correct? This is what? Banker, you are advancing money by way of loans, overdraft, cash credit, discounting of bills like this. So therefore, while doing so, you are guided by those sound principles, other principles of banking, 3 C's, 3 R's, 3 C's again. Understand? So therefore, you are, while making investment, as we told, that you are guided by these principles while making the investment. What all those principles you are guided by? There are 5 principles we have just discussed. Safety, then marketability or liquidity, then profitability or yield, then price stability, and then regularity of income as such. Now, while granting what are the, as I said, what are the two principles that you will be always guided by while making the loan or advances? One, let me tell you, one is personal security. Another one is collateral security. Collateral security. What is that personal security? Personal character of the borrower is always counted as a major confidence booster for the banker. A banker is approached by a person for borrowings, and the banker will always examine. See, he will not insist these collateral securities even at the expense of personal security, unless you believe. See, he can create a charge in respect of any of his movable or immovable property for the purpose of securing the loan. That is possible. But remember, what you need to primarily consider is that whether that personal character of the borrower can be ignored. No way. The personal character of the borrower cannot be ignored. It has to be taken care of. It has to be given priority. When the personal security, personal character itself is adhered to in the beginning, then that would be very ideal security. Over and above the personal security, personal character, if you are basing this collateral security, that's fine. But not at the expense of, the personal conduct, character wise is very, very, nuisance, is very fraud like that, then don't grant any loan or, advances to him or her, because it is incapable of it is incapable of repayment. It is, it is very remote to, expect its repayment would be done. But if the personal character, personal security, relying on his personal credibility itself is relied, then though collateral securities are not affected, still it will be made, because he will do, he will go all out to make the repayment, because he doesn't want to harm his own image. He doesn't want to impair his own reputation. That is what is required. A banker should clearly examine. A banker would clearly ensure that the borrower is a person of credibility, is a person of character. He would make the repayment. So that is always based upon. Then, in addition to, it is better. In addition to his personal security, the borrower as such, borrower property, movable or immovable, in respect of which a charge may be created. In respect of which a charge may be created to the extent of the amount lent. Okay, to the extent of the amount lent. Then there is one thing. Whatever the movable or immovable property, especially the movable property, in respect of which a charge is created so as to ensure the repayment of the money lent, then you should ensure that whatever particular movable, that is goods, in respect of which a charge is created to the extent of the loan granted, see that particular good will have the currency. What do you mean by good will be good? That particular goods will have marketability. It will have currency. It will have yield. It will sustain its value, etc. And it should not be a temporary one that it may lose its demand or prominence next. No. It should be goods of some value. And if it is not a goods of some value, don't grant it all like that. Okay. And therefore, collateral security, that means additional security, where banker will ensure, that the amount that he is lending will be sure of return, will be sure of repayment. That is why, apart from insisting upon the personal security of the borrower, some banker will insist upon borrower's property, movable or immovable property, may be subjected as a security to ensure the repayment. And these collateral securities are created in respect of movable or immovable property of the borrower. Additional security over and above the personal security of the borrower. Okay, collateral means additional, and those securities where charge is affected in respect of movable or immovable property of the borrower. And we will refer to, as far as movable I mean immovable property is concerned, we'll refer to mortgage. Movable is concerned, we'll refer to what is that, hypothecation and pledge. I think among these three, one will come. Okay. What all the various precautions to be taken in case of hypothecation by the banker? Okay. What is hypothecation? Hypothecation is a legal transaction whereby the goods may be made available as a security for a debt, but without transferring either the property or its possession to the lender. Hypothecation is an arrangement. It is a legal transaction where the goods may be made available as a security for a debt. Correct? But without transferring either the property or its possession, there is no question of any transfer of property or any possession of it to the lender as such. According to this, where the property charged with the amount of a debt, but neither the ownership nor the possession is handed over to the borrower, is handed over to the creditor, it is said to be hypothecation. You understand? Where the property is charged. A charge is created in respect to the property for the purpose of purchasing or borrowing a loan, where neither the ownership of the property nor the possession of the property is transferred to the creditor, transferred to the hypothecatee. And it is said to be, what is said to be? It is said to be, the property is said to be hypothecated in favor of the hypothecatee, that is the lender. Okay. So in case of hypothecation, it is a legal document. Remember, it is a legal transaction whereby the goods may be made available as a security for ensuring the repayment of the loan. Goods may be made available as a security for the purpose of securing the debt, but without transferring. There is no question of transfer of possession of the goods or the ownership of the goods to that of the lender. That is a speciality. And the person transferring the person borrowing the loan is called hypothecator. The person who is in whose favor the charge is created in respect to the property, and the person who is lender is called hypothecatee, and the deed is called, the agreement between them, an agreement is entered into, that is called hypothecation, letter of hypothecation or hypothecation deed as such. Okay. Now, what are the precautions to be taken by the banker while lending on hypothecation? What precautions a banker will have to take? Now you can notice these precautions are to be even taken by the banker, even in respect. Not all precautions, but this will give an idea, an outline regarding what precautions the banker is expected, because ultimately he has nothing to do with the good. In case of pledge, goods itself, the possession of the good is given to him as a security. But if it is not repaid, what he will do? Of course, he will sell it and all. But why he invite all this headache and all? But as I said, in every case, whether it is hypothecation, mortgage, lien or pledge, banker should be first of all, see, these are all collateral securities. Remember, additional securities. But first security is the personal integrity, the personal security of the borrower himself. If he is not a person of credibility, if he is not a person of character, if he is not a person of integrity, then don't choose to lend him. Understand? Don't choose to lend him at all. But personal character, if it is good, examine it. Then only if his integrity is good, his character is good, a personal security is good, then if credit worthy enough, then you proceed to lend. Over and above that personal security, personal credibility, you may go for collateral or additional security in the form of lien, pledge, hypothecation or mortgage. And while lending, you have to take precautions. Say for example, in the case of hypothecation, advance or loan on the basis of hypothecation could be given only to persons of reputation and sound financial standing. Okay, persons of character and sound financial standing. 2. Hypothecation should be sanctioned only when the borrower is not in a position to create any other charge. Hypothecation should be resorted only when the borrower is unable to create a specific charge. Right? 2. The banker should get a declaration from the borrower. That means hypothecator, to the effect that hypothecator has a clear title in respect of the movable assets to be hypothecated. Okay. Hypothecator must be in a position to give a declaration to the banker stating that hypothecator has got a clear title in respect of the goods to be hypothecated for the purpose of effecting the loan. 3. 4. The banker should obtain a declaration from the hypothecator borrower that The movable properties such as goods, etc., which he wants to hypothecate are not already hypothecated to any other banker or creditor, and that they will not be hypothecated to any other banker or creditor even in the future. You understand? This is important. See, I am the hypothecator. I want to borrow the loan from the bank on the security of a charge being created in respect to the property, and I should give a declaration to the banker stating that this particular property has not been hypothecated earlier and will not be hypothecated in future also, except hypothecating in your favor. You understand? That means earlier charge or future charge cannot be created. That sort of integrity, that sort of a declaration he should be given. Who should be giving it? Mr. Borrower, or rather the hypothecator should be giving. Okay, because banker needs to ensure the protection. As you know, this will be transfer of property when we refer section 47, I think, section 47, doctrine of priority, 48, okay, and doctrine of marshalling. Doctrine of marshalling. I mean, I think some of the elements of those doctrines found in the transfer of property, doctrine of priority, as contained in section 48 of TP Act and 56 and 81 of Transfer of Property Act, doctrine of marshalling in the case of sale and in the case of mortgage holds good. Therefore, it is ensured that in the case of hypothecation, Mr. Banker ensure that it is the goods to be hypothecated in his favor, an interest created in his favor. No, it's not been hypothecated earlier to this hypothecation, or he should ensure that the hypothecator will not hypothecate in future also to anybody for securing the loan. Therefore, this declaration has to be obtained. Banker should also obtain a hypothecation deed which serves as an agreement, which serves as a proof. Okay. Then banker should ensure that goods which are to be hypothecated by the borrower are not unsaleable in the market. That is why it is called whatever goods which the banker is accepting for it to be hypothecated by the hypothecator in favor of hypothecatee, banker should ensure that said goods will have marketable title, said goods will have marketability, said goods will have in the long run it will have the value, and when it is well done, then such a good can be relied upon for the purpose of lending as against the security of that one. Then banker must periodically inspect. That is, periodical inspection of the goods. Goods are still with in whose possession? Goods are still in the possession of the hypothecator. See, loan is given by the hypothecator. Remember, loan is given by the hypothecator. Charge is created in respect to the goods. Goods are still in the possession of hypothecator. That is what hypothecation were, without transferring the possession of the property. So therefore, banker, you should ensure that, you have lent on the faith of hypothecation, since a charge is created in respect of that property, that particular good in your favor. But you should ensure that you will conduct some periodical inspection, and visit where the property is there and check whether it is in the same position. And borrower should be asked to submit a periodical statement about the said goods, and he must ensure that this is also, say for example, if you have lent for purchase of vehicle, then you must ensure that a notice in the small form at least should be displayed in the document as well as the vehicle that it is hypothecated in favor of the hypothecatee, so that the hypothecator's attempt to to deceive or defeat the interest of the hypothecatee may be avoided. Correct? So that's what I am telling you, that one more thing is that it is better to get the insurance done. It is in respect of goods. A charge is created in favor of the goods. A loan is lent on the security of that. Possession is with you. But when it is in the possession during the loan term, when it is in the possession of the hypothecator, if the goods it may be inviting the risk, may be destroyed by fire or theft, etc. So it is better in the interest of the banker, since the possession of the good subject matter of security is still with the hypothecator, to whom you have granted loan on the basis of that, if it is while in possession of the hypothecator, if it is destroyed, better you will lose. Therefore, you better get it insured. You understand? So get it insured. Mr. Hypothecator, yes, I am agreeing to lend on the basis of that, provided you create an insurance policy in favor of the said goods. If all done, then Mr. Banker, you are ensuring that whatever money that you are lending on the faith of the hypothecation, since there is a little bit of risk, more risk, unlike pledge, where the possession of the goods is still with the possession of the goods are transferred, whatever the charge, the specific charge is created in respect of the goods, that possession of the goods itself is transferred to the pledgee, so pledgee will be more secured. But in case of hypothecation, it is not so. Pledgee is unsecured. The hypothecatee is unsecured that way. Therefore, I am telling you that hypothecator should ensure that he should be lending in case of hypothecation. These many precautions a banker should be lending. Okay, and again, mortgage. What is the meaning of mortgage? Transfer of a specific interest in the transfer of a specific interest to the mortgager in respect of that is immovable. Transfer of an interest in the specific immovable property by the mortgager. Mortgager transfers a specific interest of his immovable property in favor of mortgagee for the purpose of purchasing the loan or for the purpose of ensuring. It is said the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan existing or future, or for the performance of an engagement which may give rise to pecuniary liability. This is what the meaning of mortgage. Section 58 of the TP Act defines mortgage. What is that mortgage? Transfer of an interest in respect of a specific immovable property. Transfer of an interest in respect of a specific interest in the immovable. Transfer of an interest in respect of a specific immovable property for the purpose of what is that? For securing, this is important, for the purpose of securing the payment of money advanced or to be advanced, either by way of a loan, which may be either existing or future loan, or for the purpose of performance of an engagement which may give rise to pecuniary liability. The person who transfers the interest in respect of his immovable property is known as mortgager. The person to whom the specific interest in the person to whom the interest in that specific immovable property of his is transferred is known as mortgagee. What is the object of mortgage? The object is to secure the payment of money advanced or to be advanced, either by way of loan, either existing or future, or for the purpose of performance of an engagement which may give rise to pecuniary liability. Okay, therefore a mortgage is created. Transfer of interest in respect of your specific immovable property. If you want a loan, if you want to borrow from the other person may be insisting, correct, okay, I will be lending, provided you will be transferring your specific interest in respect of your immovable property. You will be transferring your interest in respect of your specific immovable property to my favor for the purpose of, because I want to secure whatever loan I lend, either existing loan or future loan, I want to secure my loan along with the interest, correct? Along with the interest. So how is it possible? Securing the loan as well as the interest is possible only when a document is executed in my favor, ensuring that the loan lent is secured of its repayment. This is to be guaranteed. Therefore, immovable property, this will apprehend the borrower. I have borrowed and I should repay. If I don't repay, then he will go to the court and cause the property sold for realizing. I will be losing the property. There are various provisions pertaining to mortgage. Section 58 to almost section 105 it deals with, correct? Of course, 99, 100 is charged, right? Where you will deal with mortgage, different kinds of mortgage, doctrine of redemption, doctrine of clause on redemption, doctrine of foreclosure, doctrine of consolidation under section 61. Then you have got doctrine of substituted security under section 62. Under section 72. And there is one more doctrine of marshalling, doctrine of subrogation, doctrine of contribution, doctrine of that is called prohibition of tacking. And then you have got doctrine of merger. So many are there doctrines. These doctrines are nothing but the provisions. Okay. As far as these doctrines are concerned, it will not put the mortgager in a beneficial position so as to suppress the interest of the mortgagee. Say for example, doctrine of redemption. Once a mortgage is always a mortgage, nothing but a mortgage. Once a mortgage is always mortgage, nothing but a mortgage. That is the provision. But don't think that a mortgager, if he doesn't repay the money, then mortgager need not think that hey, I will get the property under section 60. Doctrine of redemption is there to my favor. No. If you keep waiting, then the property may be sold by giving a notice. Because you have not repaid the money. But if you exercise the right of redemption, even if it's sold, say for example, the mortgagee has sold the property to B. Now, you may file a case to redeem your property. Of course, mortgagee has sold the property for the purpose of realizing his money. Okay? But, Mr. Mortgager, you on the reliance of this protection provided under section 60, that is doctrine of redemption, you may file a case in the court of law to redeem your immovable property which has been sold by your mortgagee to Mr. B. You can redeem, provided you have to pay. Redemption is not possible without adequately compensating. What is that adequate compensation? What is that amount you have borrowed? One, that you have to pay. Plus, what is that expenditure incurred by the mortgagee for effecting the sale? These you will have to repay. Then 100% Mr. B, you cannot argue that hey, I have become the bona fide owner, I will not give. No, you cannot say. And even you cannot take the what is that called shelter, or you cannot take the protection under section 53A. That is the doctrine of part performance. Even that is not available to you. Doctrine of part performance is also not available to you. Reason, it is sold by the mortgagee so as to realize his property. But one thing let me tell you, that mortgager can always get back the property, redeem the property from that innocent purchaser, whatever it may be, provided he should be paying whatever that innocent purchaser paid to the mortgagee plus whatever mortgagee has incurred for effecting the sale. This you will have to pay, Mr. Mortgagee, and get back the property. Once a mortgage, always a mortgage, nothing but a mortgage. That's what I said. Unless, if you don't repay Mr. Mortgager has recourse to or taken the provision of section 67. That is doctrine of foreclosure. He wants to foreclose. Mortgage from the date of effecting is valid for a period of 30 years. There cannot be any clause or prohibition or restriction in that right of the mortgager. As I said, don't you think the mortgager has filed a suit against that B and could recover? But this right of mortgager, that is redemption, can also be prematurely closed if the mortgagee files a case under files a suit for foreclosure under section 67 of the Transfer of Property Act. Banker, you should and the banker, you should also know whether the property mortgaged by the mortgager, whether for your lending, Mr. Mortgagee, to the mortgager, and a proper immovable property of his, interest is transferred to your name, to your favor, Mr. Mortgagee. But ensure that whether it is subjected to any earlier mortgage, whether the mortgager has borrowed money from any other bank or any other person by creating a mortgage in respect of the property, then I think suppose even if you have examined it, you could not get it, could not detect it, but subsequently after you were lending to the same mortgager, if you come to know that this was subjected to earlier mortgage, then one thing, you have got doctrine of marshalling. You are entitled under the you are entitled to protection under section 81, saying that the prior mortgage, understand, the prior mortgagee is entitled to have the debt realized out of the property not mortgaged to him. You understand? So the later mortgagee, you are the later mortgagee, bank, and you have lent without knowing, examined but could not get it. But subsequently you came to know that it is subject to earlier mortgage. So later mortgagee, that is what the bank, he is entitled to have the prior mortgage realized out of the property, not mortgaged to him, not mortgaged to later mortgagee. This is what the protection. Later mortgage is right, it is. Whatever property that is, an interest is created in favor of the later mortgagee, barring that property, any other property, I mean to say that whatever property not mortgaged to later mortgagee, the earlier mortgagee can realize. Earlier mortgagee cannot realize his mortgage money out of the immovable property that is mortgaged to later mortgagee. This is what doctrine of marshalling. Later mortgagee is entitled to marshal that earlier mortgage should realize the debt out of the property not mortgaged to later mortgagee. I think Mr. Banker should be completely aware of all these. There are different kinds of mortgage, So therefore mortgage means transfer of an interest in specific immovable property by the mortgager to the mortgagee for the purpose of securing, securing the payment of money, advanced or to be advanced by way of existing or future debt, or for the performance of an engagement which may give right to monetary or pecuniary liability. And there are different types of mortgages. Normally there are 6 types of mortgages, excepting the 2, English mortgage and usufructuary mortgage. In all other, there is no question of a transfer of physical possession of immovable property to the mortgagee. Maybe document of title deeds. Like I'll tell you, in case of simple mortgage, there is no transfer of immovable property in favor of the mortgagee, but an interest is created in his favor with a specific personal obligation that I will undertake, mortgagor will undertake to repay the money to you. In the event if it is not, then you can go for the court to get the possession of the property as a security. But in the case of simple mortgage, there is no question of transfer of a physical possession of the where without delivering the possession of the property, mortgagor binds himself personally to pay the mortgage money and agrees expressly or impliedly that in the event of his failure to pay according to the contract, mortgagee shall have the right to cause the mortgage property to be sold. That's what I mean by. This is called a simple mortgage. But whereas mortgage, usufructuary mortgage, there is a transfer of, say, I am the mortgager. I go for 5 lakhs loan and I have borrowed it from the mortgagee. Okay, but with the and security in respect of an interest in respect of my immovable property is transferred by me, the mortgager, to the mortgagee. You understand? There is a transfer of an interest taking place. Transfer of an interest is effected in respect of the immovable property of the mortgager to the mortgagee. Not only that, but also the physical possession of the mortgage property is given to the mortgagee with in a condition that the mortgagee should realize the mortgagee should realize the mortgage money, that money lent, debt, out of the property that is put in his possession. You understand? The immovable property is subjected as a security. Remember, where in case of a usufructuary mortgage, the mortgager secures the payment of money by way of loan on the ground of transferring his interest in the immovable property, not only transferring the interest in the immovable property, but also transferring the physical possession of the immovable property to the mortgagee. Now, whatever mortgagee has lent, mortgagee has to recover it from out of the yield or proceeds that are coming from the mortgage property. Where is it? It is with you only. That is what we mean by when mortgagee you realize your mortgage money, then you retransfer to mortgager as such. That is mortgage by usufructuary mortgage. Then mortgage by conditional sale. Once again, no question of transfer of property taking place here. Physical possession is not there. But in case it is like simple mortgage, in case if he doesn't pay, then it becomes a sale. That is what the agreement that mortgager has undertaken. Mortgager asks mortgagee, give loan on the security of the immovable property. Mortgagee says, if it is not paid, it becomes sale. Yeah, definitely. So mortgager, you be aware, mortgage by conditional sale, wherein on the default of the payment of mortgage money on a certain date, then it is right now it is conditional sale. This kind of mortgage is conditional sale. But on your default to pay when the time is due, it becomes absolute sale. Okay, but even in the case of this, right of redemption is available to the mortgagee, because right of redemption is to redeem the property for a period of, right of redemption is recognized by Transfer of Property Act for a period of 30 years as such. Then we have got English mortgage, then we have got, so 4 mortgage, then we have got mortgage by deposit of title deeds, and last one we have got anomalous mortgage. Anomalous mortgage, it says, anomalous mortgage, it means where the mortgage, which is not a simple or mortgage by conditional sale or usufructuary or English or mortgage by deposit of title deeds within the meaning of section 58, then that mortgage is called anomalous mortgage. It simply means that anomalous mortgage includes mortgage formed by combination of 2 or more of the above types, I said. So, Mr. Banker, you should ensure that which mortgage, I mean, you are going to grant the loan, you know the meaning of mortgage, which mortgage you will rely on, and you must also be aware that there is a right available even if you go for mortgage by conditional sale or simple mortgage, etc. You may cause the property sold, or your conditional sale becomes absolute sale when the default is committed, etc., etc. Still, mortgagor can exercise his right under section 60, right of redemption, unless the mortgagee has exercised his right under section 67. A banker, you should be aware that when you are granting a loan on the faith of transfer of on the faith of mortgage transferring his interest in the specific immovable property, then for securing the loan it is made whether to take the possession or to keep the possession with him only. You should think of which particular mortgage will be safe as far as your repayment of the loan lent is concerned, and ensure that when you have lent, when the property is there with the mortgager, then you should be taking adequate precaution. 1, he should be a person of integrity and honor. 2, that it is not subjected to earlier mortgage. He has not created any earlier mortgage, and neither he will create a future mortgage. Okay, he should get a declaration, and then he should put a display that this property is mortgaged in favor of there in the document itself, this property, and as a placard also may be kept in the said property as such, because Mr. Mortgager may attempt to sell it or create another mortgage, thereby deceive the innocent buyers or innocent mortgagees. Therefore, you should ensure that adequate precautions and frequent inspections may have to be conducted by the mortgagee in respect to the mortgaged property. You understand, right? All these, precautions Mr. Banker will have to undertake while lending against the mortgage as such. Okay, right? Can you distinguish between a pledge and hypothecation? Let me tell you. In case of pledge, there is possession. There is a physical transfer of possession of the goods for securing the loan. In case of hypothecation, it does not take place. It still remains with Mr. Hypothecatee as such. Okay, right. Second one, in pledge, pledger cannot deal with the goods pledged with the pledgee. In hypothecation, hypothecator can deal with the goods. He can enjoy with the goods. Of course, he cannot transfer it. That's it, by any means. In case of pledge, the pledgee can sell the pledged goods without an order from the court when the default is committed. But in case of hypothecation, the hypothecatee cannot sell the goods hypothecated without an order from the court. In case of pledge, the pledgee can sell the goods pledged without an order of the court. But in case of hypothecation, he cannot do so. He has to do so only with the order of the court as such. Likewise, pledge and can you distinguish between hypothecation and mortgage? Yes. Hypothecation refers to movable, mortgage refers to immovable. Hypothecation can be created without executing or registering any document, whereas mortgage by registering a document called mortgage deed. In hypothecation, legal interest or title of the property hypothecated is not transferred from the borrower to the lender, but in case of mortgage, it depends upon which type of the mortgage it is. It may be either with the mortgager or it could be transferred. That's what the difference as such. Like usufructuary mortgage, like a legal mortgage, it may be transferred to the borrower. It may be transferred to the lender, that is mortgagee as such. Then a hypothecatee has no right to sell the hypothecated property without an order of the court, unless it is provided that letter of provided, unless such a clause is provided in the letter of hypothecation. Therefore, hypothecator cannot sell without the order of the court. The property hypothecated, the movable good hypothecated. But whereas in case of a legal mortgagee, he has the right to sell the mortgage property without an order from the court as such. Okay. Then for a creditor or lender, mortgage is better than hypothecation. As I said, pledge is better than hypothecation. Mortgage is better than hypothecation for a lender or for a creditor. Okay, right. Then these many are, as far as the investment is concerned, I have discussed all this. In case of pledge, what all the various provisions. The provisions relating to pledge is contained in meaning of pledge. It is a kind of bailment. Okay, and pledge is the bailment of goods as a security for the purpose of a payment of a debt or performance of a promise. And the person pledging the goods called pawner or pledger. Person to whom the goods pledged as a security called pawnee or pledgee. Essential features of pledge. Pledge refers to movable property such as goods, documents, and valuables. An agreement between borrower and land is essential. Borrower and lender is essential for the creation of pledge. A pledge is created when the subject matter is delivered to the lender as a security for repayment of the loan as such. This is very essential. In pledge, the ownership of the property pledged remains with the pledger, and that ownership is not, only possession is transferred. Okay. Then the pledgee has a right to sue the pledger or sell his goods in default of the pledger. Correct. And section 148 of the Indian Contract Act also defines bailment. Bailment is the delivery of the goods from one person to another person under an agreement that when the purpose is over, the goods shall be redelivered to the person from whom it is derived, called the bailer. And to be delivered by whom? Yes, by the bailee as such. Okay. There are different kinds of bailment. As I said, bailment for the use of the bailer, bailment for the use of the bailee, bailment for the use of both. You should be aware. So whether you will be granting the loan on the faith of pledge or on the faith of lien. Lien, if you are granting loan, means you must have the possession. Or on the faith of hypothecation. As far as pledge and hypothecation for the lender or the creditor, pledge is rather good. But in some cases, transfer of a specific interest, in case of, what is that? I will tell you that in case of a hypothecation, in case of why, hypothecation takes place. In some cases, when the hypothecator is unable to create charge, is unable to create a specific charge in respect of a property, then hypothecation would be better. Or in some cases where hypothecator needs, if the possession of the goods in respect of which loan is taken, maybe a vehicle loan, for example, vehicle is needed, otherwise how to pay the loan installments and all. That's what it is difficult without the possession. The possession is to be enjoyed. Therefore, in such cases, I think pledge won't be useful. Hypothecation, where it is possible, go for the pledge. Where it is impossible, then banker with all precautions go for the hypothecation. And in case of there is no question of pledge of immovable property or hypothecation of immovable property. For that, you should always rely on mortgage. Question will be coming on this. Explain the precaution to be taken. Explain the various principles to be adhered. What all the various precautions to be taken while advancing loan against the security of goods or immovable property. So to sum up, I will tell you, against the security of goods, Mr. Banker, you should ensure that against the security of goods, you should ensure that these precautions you will follow. What all those precautions? 1. Selection of honest borrower. As I said, integrity of the borrower. 2. Method of charging or creating interest. What is that? Whether you go for pledge, whether you go for hypothecation, whether you go for lien, or whether you go for bailment. So that you should be very careful. 3rd one, storage of the goods. Where to keep the goods. Suppose if the goods are taken taken by the lender as a security, if the possession of the goods is transferred by the borrower to the lender as a security, Mr. Lender, where you will keep, where you will store the goods, which is the subject matter of security. That is also right too. Then get it insured. Insurance is to be done in respect to the goods. Otherwise, when the goods are subject matter of security is destroyed, then Mr. Lender will be in risk. Therefore, you should get it insured by the by the hypothecator or pledger or bailer as such. Then in respect of that insurance charges, rent of the go down, etc. to be paid by the, if paid by the banker, then should be recovered from the borrower. To get a declaration that borrower you will be liable for all this. Then knowledge of the commodity. See, whatever the goods which is subjected as a security, banker should have the knowledge of its marketability in the market, knowledge of the goods in the market, and then it should be properly valued. Don't go for wrong valuation. Overvaluation or undervaluation should not be done, because there should be, first of all, when the borrower wants to borrow the loan on the faith of the property, movable or immovable, first of all it should be valued. What is that valuation? Don't quote under or overvaluation as such, right? Then some legal requirements like say for example, Reserve Bank of India under its selective credit control scheme issues from time to time directives regarding granting of advances against goods and commodities. These legal requirements must be followed by the banker as such. Okay. So and the next one is that employment of bank funds either for granting of loans and advances. What precaution to be taken? Ensure that you are going to not only relying on the personal security of Mr. Borrower, but also you may insist for some collateral security, the additional securities which the borrower must create a charge in respect of the lender as such, and it may be affected by way of goods and it may be lien, pledge, hypothecation, immovable property, it may be lien or mortgage as such. Okay, therefore, Mr. Banker, you should not only lend, but also you should secure the loan lent along with the interest, secure of its repayment. Then you have to be, bothering about the employment of bank funds by way of investment in government securities, government bonds, securities of public sector undertakings, and then industrial securities. Even there are, other securities like, let me, get you the other securities that exists, namely the semi-government or trustee securities. Okay, government securities, government bonds, semi-government or trustee securities, securities of public sector undertakings, or industrial securities like stocks, markets, stocks, shares, debentures, etc. Remember, not all the industrial securities, but industrial securities of reputed companies that are doing good in the stock market. You understand? In such cases, you can invest. And investment is a risky investment, because investment subject to market risk, they will say always. Therefore, there while making the investment, Mr. Banker, you must be very selective, like you must be adhering to these norms, safety principles, and its marketability and liquidity, because it must be, at any point of time with the banker willing, therefore I said that it must be in the liquid form or marketable form, then profitability or yield, then price stability, then regularity of income, and another one is that it is easily negotiable. You must be, see, if you are investing in the stock, then investment in such in the securities, investment of funds in securities like government securities, bond, or as I said, semi-government or public sector or industrial securities, etc. These principles you are to be guided by. Why? Because without ensuring those secured principles, the sound principles of banking, it is not possible for the banker to exist at all. Because if he is to exist, then he has to invest. He has to employ the funds by way of, he has to employ the bank funds either by granting the loan or advances or by making investment. Then wherein only he will earn the profits. From out of these profits only, he will be in a position to give the rate of interest, the agreed or promised rate of interest to the borrower, to the depositors, as well as he is in a better position to earn profits, to earn salaries, and from out of that he can meet administrative expenses. Understand? very important infrastructure or administrative expenses as such. So these precautions you will have to take. This is a part of your unit 5. And there is one more, that in the modern times, banker is not remaining in the, banker is no more remaining in the primitive form. A banker is in the most advanced form, and it keeps advancing. Today we are finding not the conventional mode of banking as we used to see in the year 1970, 80, etc. We are able to see now the technology driven banking operations today. We know how account is operated. Without going to the bank, account can be opened. Without going to the bank, account, money can be deposited, money can be withdrawn. In the past, we used to see that there are limited withdrawals applicable to current the savings account and all. Today, there is nothing like that. Of course, they are imposing charges, okay, for all those operations. Right now they are now contemplating that if you use ATM to draw more than 5,000, then it is chargeable. Some charge will be imposed on the ATM card holder and all. They will be saying all those. But principally what I am telling is that those are the technology driven banking operations that we find today, and they are improvements. Of course, they are needed to fasten the banking operations. If banking growth, if the banking operations cannot improve, then we will again, if at all we find today the market operations in this most advanced, most speed growth, I think everyone is having banking habits. In the olden days, if you go back to 70, 80, banking habits were there with only very few. I don't think with all households, but today banking operations are there even with the children. To that extent, today the banking operations where you don't go to the bank. There is RTGS, there is NEFT, there is mobile banking. Mobile banking could be understood in two meanings. One is that your mobile banking. Another one is that their own unit, the banker's unit go mobile. Where there is unbanked area, they will take a mobile unit of their bank to that area, and they will fix that we will be coming to your place to conduct banking operations once in a week or twice in a week or thrice in a week. It is like a mobile hospital. So that way also you can. And then core banking, network banking, totally we can say that e-banking. We call in the commerce or trade as e-commerce. Here there is e-banking. NEFT, RTGS, these days it used to be subjected to some charges, but these days Reserve Bank of India has morally persuaded the banks provide this NEFT and RTGS free of charge. You go for NEFT, that is National Electronic Fund Transfer. Okay, there is also one more SEFT, that is Secured Electronic Fund Transfer. And it is considerably for smaller amount, transfer from one bank to another bank to the accounts. But when it is when the transfer of a larger amount, then go for a quick settlement, real-time gross settlement. Real-time, I said, it will really go in such real-time, double quick time from one bank to another bank when it is opted by the customer. Usually the minimum amount, not that banker will not permit, but there is no maximum limit as such for transfer of fund from your account to another account, your bank to another bank. There is no maximum limit prescribed under the prescribed by the RBI directive, but there is a minimum limit as far as 2 lakhs is concerned. But let me also tell you one thing. For RTGS 2 lakhs, but if the bank decides, then they can even allow you 50,000, 1 lakh, 1,50,000, 25,000. They can go for. It is up to them. But instruction is that you can go for NEFT. Why do you go for RTGS? When NEFT is there for smaller operations, then avoid going for RTGS. And if you are still going for RTGS, then you may be imposed of some RTGS charges. That is there. I mean, these are all. Earlier we used to send MO, money order. Okay, or we used to send DD. You get the DD and post it to the addressee to whom it is meant. It will take at least, it has to be sent through registered posta, speed posta, whatever, the form is there. It will take at least 2 days. And then for realization 1 day, 3 days. In the past 15 days, I'm telling you. But at least today it will take about 3 days. But if you go for this RTGS or NEFT, it will take, I think, not even 1 minute when everything is clear. This is what the technology-driven banking operations, and everything has gone digital. You don't need to have the hard cash in your possession. If you have those what is that called, ATM credit or debit card, that's all enough for you. But of course, the technology-driven banking also contains in itself huge risk. What is that risk that you are seeing today? What is it? Hacking and what is that? Collecting through fraudulent means your PIN number, all those information. Then SIM swap. All these have come. Technology-driven banking. Only it requires that a person who is not familiar with the techniques may be exposed to more danger or risk, that because he is not knowing what kind of cyber crimes could be committed, and it is being committed. We have the instances to prove that. Even the Director General of State Police got duped by this method of what is that, asking for the details of the account, manager talking from your bank, SBI, something like that. So you don't be a victim of those. You must have at least the basics. You better lock it and give a direction to the bank that in such cases amount should not be. And now it is there. It is there to secure you. Even if you issue a check, you have issued. Mr. Customer of the bank has issued a check in respect of smaller amount. No. A check in respect of a larger amount. When it is going for clearance, your banker will ensure that he will send you SMS that a check issued by you bearing number has come for collection. And if we don't receive by 12:30 or 1 o'clock today, we will proceed to honor that. We will proceed to clear it. That means you will come to know. That means banker will provide some sort of protections to you. You will come to know suddenly that, oh, I have not issued check. How come? You will instruct the banker not to. But if it is issued by you, you either keep quiet. You don't need to call the banker and disturb his business. If it is issued by you, banker has, for the convenience of providing you the safety, he has provided this sort of SMS facility. Right? I said, that's what. Who is not having? Everyone is having. How many accounts is having? He is having the spare accounts. That is the difficulty in the modern time. Our deposit with the bank is guaranteed. It was guaranteed till February for 1 lakh. Now it is guaranteed to 5 lakhs. Is it not a guarantee? Is it not a protection? Is it not a protection? It is. Deposit insurance credit guarantee scheme. Banker's loan is also guaranteed up to 5 lakhs. I said up to 5 lakhs, not insurance it is. Up to 5 lakhs, not insurance in the sense. If you had only 50,000, if the bank goes into liquidation, you will only get 50,000. Don't think that I will get 5 lakhs. It is not insurance to that. Insurance means a guaranteeing to the extent of 5 lakhs. If at all you had whatever amount up to the extent of 5 lakhs, that actual amount you had in your account you will get. This is what Deposit Insurance Credit Guarantee Corporation of India Act 1962 provides. All these securities are there to ensure, though the technology driven banking today has conquered the banking operations, that everyone is having banking habits. The question only that when I have 3 or 4 accounts in different when I have 3 or 4 accounts in different banks, whether I will be subjected to that insurance scheme in all the banks is only a question that will be answered in the very near future by the government of India, because as of now there is ambiguity. Government as of now there is ambiguity that your total amount is guaranteed up to 5 lakhs, they say, put together all. But if that is the case, then people may not bank with other banks. People will bank with only one bank. Such may be the coming. Anyhow, the clarity is to be given by the RBI as far as that scheme is concerned. But what I am telling is that we have got various technology-driven banking, and these are not at the expense of the traditional sound principles of banking. Acceptance of deposit and lending of funds is the main function of banking, will remain main all the time. And to support that today, to support that banking operation and to glorify, to color, to facilitate the customers, this technology driven banking has taken place so as to speed up. Understand? That's it. This is what Unit 5, all these are figured in the latest trends Okay, ATMs and ATM kiosks wherein you will find everything, passbook, get entry, statement you required, press the button, put the number of the account, and get the balance sheet, the statement of your accounts. Then you go for deposit of checks. All these digitally, all in the ATM machine, you can get it done. This kind of digital era, digital operation of the bank is taking place. Of course, I think from birth to death, I think the influence of banking as far as sustenance or growth of our economy, it cannot be underrated. Today, its role is huge in promoting our economy. It can promote or demote our economy in no time. Therefore, banks should be honest. RBI's role, especially in the modern era, is huge. RBI, if it errs little, then it will upset the economy of individuals and the country as such. Okay, right. Thank you very much.